Why filing an appeal of your denied or terminated ERISA disability benefits without having a copy of the claims file is the worst mistake that you can make after not hiring a lawyer. Let me explain why. If your claim has been denied or terminated, you'll have 180 days in which to file an appeal. That appeal is the trial of your case. If you don't have the claims file and you're just operating off of a denial or termination letter, you're flying blind, because the gold and the bombs in your case are found in that claims file. In other words, you can get an understanding of what information they had, how they applied the policy terms, what liar for hires they may have used, how they reached their vocational conclusions. All of that is important so that you understand why they got to where they got and how they got there. Of course, if you ever end up in front of a federal judge, the judge is going to be first looking at the policy to determine the applicable standard of review and applicable definitions. But more importantly, they're going to be looking at that claims file. And if you've written an appeal letter that does not address the real reasons for the denial, and only what you think are the basis of the denial or termination based on that denial or termination letter that you got, you're making a mistake. Why? When I am writing an appeal, my appeal letters are 15 to 65 pages long, and I'm starting out with the claims file. I take that claims file apart and I understand what the adjuster's notes have to say, why they did what they did. I'm looking at their peer review reports, how their doctors reached the conclusions that they reached. Same way with the vocational rehabilitation counselors. This really is the story of your case, and it's the basis for the beginning of writing a winning appeal letter. If you try to write an appeal letter on your own, which I don't recommend, but if you do and you don't have the claims file, it's like taking an examination in school without ever having read any of the case or the file material or the books, and not attending class. You've got no clue. You think you're just going to walk there and wing it based on the course syllabi. That is not going to cut it. You need to have a copy of the claims file, a copy of the policy, and you need to really take all of these apart to understand the legal, medical, vocational, factual basis for what the carrier has done or the plan has done, and then begin to think about what proof you need to submit and what law you need to argue that's going to result in an overturn of the denial. If you're trying to wing it, that's exactly what's going to happen. You're going to wing it. Give us a call at 727-894-3188 for a complimentary consultation so you can learn more about your rights to your ERISA disability benefits and what you should be doing in filing an appeal. 727-894-3188.